Hey everyone, welcome back to the channel. You may have seen my earlier video on the top 5 most frequently asked questions about wills in Singapore. In this second video, I will answer another 5 more. Frequently asked question number 1. What is an executor and who should I appoint? An executor is the person responsible for carrying out the terms of your will. They manage your estate, settle any debts, and distribute the assets as per your wishes. Choose someone you trust. This could be a family member or close friend. Ideally, you should appoint the biggest beneficiaries under your will as executors because they stand to benefit the most. If you appoint someone who has nothing to inherit as executor, he will likely refuse to execute the will. In such situations, it would be prudent to specify that if this person acts as an executor, he will be paid a token sum for his trouble. For example, $5,000, $10,000, $20,000. You can even appoint professional executors, including lawyers. You should also note that you can appoint more than one executor, and you ideally should appoint at least 2 executors in your will in case the first one dies or is unable or unwilling to act. Frequently asked question number 2. Can I disinherit someone in my will? Yes, of course you can. You can specifically state in your will that someone is not to inherit from your estate. Your will could state something along the lines of, I expressly declare that I am excluding my son, Winston Chua, from my will and that he shall not inherit any part of my estate as he is not on speaking terms with me and has not contacted me since 2010. However, be mindful that disabled children or a spouse have the right to contest the will under the Inheritance Family Provision Act if they feel inadequately provided for. Question number 3. What if I own property overseas? Will my Singapore will cover that? Well, your will can cover overseas property if that country recognizes foreign wills. Most Commonwealth countries will recognize Singapore wills because their wills law is based on English law. Countries such as Indonesia, Thailand, Cambodia, Vietnam, Philippines, and many European countries do not recognize foreign wills. As such, it's often advisable to have separate wills for each country where you hold property. Different countries have their own laws regarding wills and estates, so consulting a lawyer familiar with the jurisdiction of your overseas property is a good idea. FAQ number 4. Can I name a guardian for my children in the will? Yes, you can and you should name a guardian for your minor children in your will. This ensures that in the event that you and your spouse are dead, whether because you died at the same time or shortly one after the other, your children are cared for by someone that you trust. The Guardianship of Infants Act specifically provides for guardians to be appointed under a will. The courts will generally respect your choice of guardian, although they will always prioritize the best interest of your child. FAQ 5. Do I need to update my will? Absolutely. Major life events such as marriage, divorce, the birth of children, the death of a beneficiary under your will, or the acquisition of significant assets are all reasons to update your will. In fact, under Singapore law, marriage will cancel or revoke an existing will unless the will was made in contemplation of marriage, i.e., if you plan to marry someone at the time that you are making your will should declare that as at the date of the will, you plan to marry so-and-so, and further declare that the will shall not be cancelled by such marriage. So there you have it, answers to another top 5 most frequently asked questions about wills in Singapore. Please hit the like button and subscribe for more legal tips. Thank you for watching.